go ahead and introduce Professor Atkinson here in a minute. I just want to see if we, let's see, I'm just trying to see our recording if it started, or I might, oh, I think we are recording. Okay. All right, welcome everybody. Again, my name is Diane Steele. I'm the Director of Admissions with San Joaquin College of Law, and I look forward to helping all of you as you move forward with this application into law school. In a minute, I'm going to turn it over here to Professor Atkinson. Professor Atkinson teaches our contracts class. He also serves as our academic dean. Professor Atkinson formerly practiced as Associate General Counsel for the Community Medical Center. He served as Deputy County Counsel for Fresno County, and he served in general litigation with the Fresno law firm McCormick Barstow. In law school, he was an executive editor of the Utah Journal of International Law, and he published work on topics related to international law and literature. Before attending law school, Professor Atkinson taught Spanish and Latin American literature at the University of Utah. So I'm excited now to turn it over to Professor Atkinson. If you could please introduce yourself a bit more and share with us your passion for law and help us understand a little bit more about what to expect in contracts. Professor Atkinson.
Thank you, Diane. Hopefully everyone can hear me. Welcome, everybody. It's good to have you here. What I want to do today is kind of show you what a class will look like at San Joaquin College of Law. Generally, I would have you in front of me here and we'd be talking and having a discussion. And that's one thing that I wanted to show you is that law school is not going to be a PowerPoint where I talk at you. You know, law school is a discussion. You'll come to class having read the cases that were assigned, and we walk through the cases and we discover what the law is. We take out rules, we apply them to facts. And so that's kind of, I want to put you through that. Now, it's kind of different. You know, I'm in a physical room here, as you can see, got a whiteboard, and I'm going to kind of act like you're here with me because that's what the experience is going to be. So if you want to answer questions or jump in, you know, please do so. One difference that you'll see today is I'm going to ask for volunteers. When you're in class, generally speaking, I just call on you, right? Now, I know that sounds daunting a little bit, but I think that especially at SJCL, we all feel part of a community, and I hope you feel comfortable being called on. And for the most part, I think you, even the most fearful student of being called on, you know, by the end of the first semester, they're used to it and they just know it's one of our teaching tools. And I think that you'll discover that it's a good teaching tool. So again, we're trying to emulate what the law school experience will be like. And so the first thing that I would do is I would say, okay, Mr. So-and-so, take out Allison Sullivan versus James O'Connor. I pick one of you. It's the second case that I gave you today. We're going to focus on that today. Take that case out. I'm hoping you had a chance to read these. So I'm giving you a second to pull out Allison Sullivan versus James O'Connor, right? Okay, so what I would say is I'd pick someone out. I would say, Mr. Goodnight, right? I would say, I don't want to scare you there because I can see some surprise there. I'm hoping you can all hear me too. I would say, Mr. Goodnight, or whoever wants to jump in here. We're looking at this case. What are in contracts, we always talk about the parties. Who are the parties and what's the B? So tell me, who are the parties in this? Who's the plaintiff in this case? Anybody?
Alice is the plaintiff.
So we got Sullivan, right?
Sullivan, I'm sorry. Yes. Sullivan is.
Alice Sullivan, you're good. We can say whatever name we want to. It's good. So what I'd like to do is I like to, you know, Sullivan is the patient, right?
Mm-hmm.
Okay. What else? What else is Sullivan? How does the court describe her?
An entertainer.
He's an entertainer, right? So we got Sullivan, who was an entertainer, and we're going to find out if that's important or not. Entertainer, right? So we've got Sullivan, patient, entertainer. This is the plaintiff, right? And the defendant, the person being sued, is whom?
Plastic surgeon.
Surgeon, right? So it's O'Connor. Let's say doctor. Those doctors. Okay. Sorry, doctor, right? Okay. Now, what was the agreement that they had? So again, this is the contracts course. So I go right out and I say, what is the agreement that they had? This one's easy. On this side, I'm gonna make arrows here, right? I'm gonna say Sullivan was gonna do what to doctor?
She hired him for him to do a nose job.
And what was she gonna, what this arrow going here, what is she going to perform? What's her duty under this contract?
She's gonna pay him for that service.
He's gonna pay money, right? On this side, we've got paying money, right? The doctor, in exchange for that money, is gonna perform surgery, right? What type of surgery are we looking at?
Plastic surgery.
Plastic surgery, okay? Specifically, what?
Nose job.
A nose job, right? So we're gonna have surgery, we got this, a nose job, all right? Now, I'd like to give a little background to students about this case. Hey, what the doctor said is that he was gonna provide a nose that looked like Hedy Lamarr. Does anyone know who Hedy Lamarr is? This is an
No.
actress, I think from Austria or Germany from the 40s or 50s, who had a very nice nose, right? A very shapely, nice nose. So apparently this doctor promised to perform a nose job like that of Hedy Lamarr. Specifically, what are the promises that you say that he made here, that she says that he made?
I think I remember reading basically that it'll look better than it did when before she went to surgery.
It would look better than it did before she went to surgery, okay? What else? What are we expecting here?
There was a promise to enhance her beauty and improve her appearance.
A promise to enhance her beauty and improve her appearance, right? So, okay, that's promise to enhance beauty, to improve the appearance, correct? But what happens?
It doesn't go very well.
Doesn't go very well. Specifically, according to this nose, do we have a nice Hedy Lamarr nose?
No.
No, okay. What does the court say the nose looks like?
In layman's term, it's a little lopsided. It's not
So,
even.
her nose now has a concave line to
Yes.
about the midpoint, at which it becomes bulbous. Viewed frontally, the nose from bridge to midpoint was flattened and broadened, and the two sides of the tip had lost symmetry. Importantly, this configuration evidently could not be improved by further surgery. Okay, so we have basically, what is plaintiff claiming? I should ask that before we start. What is plaintiff's complaints? What do they sound like? What type of law? I already gave one, right? I already gave contract breach. So we've got one sounding in contract, meaning an exchange of promise.
Duress,
Right?
emotional duress,
I'm sorry, could you say that again?
emotional duress,
Emotional duress is a result of one of these claims being fulfilled, right? So if there's a contract breach, that could equal kind of this duress element, this emotional duress. But there's also one in what's called tort, right? This is what's called negligence. I'm sure you've heard of negligence before, right? And what tort is, it's a civil wrong. So in this case, what she's claiming is that the doctor should have performed to this level, right? Like this is the level of care the doctor should have performed. The doctor fell below that, right? Performed at this level of care. So that would be a negligence cause of action. And how did the jury find on that? In terms of negligence.
can you repeat your question? How did the jury?
How did the jury find in this negligence claim of action? Did they say this negligence claim of action had merit?
I believe they did, right?
It did not, Mr. Goodnight. It did not, right? So we're gonna kick out this negligence claim of action, right? We're gonna kick that out. So we're left with contract, okay? We're left with this contract. So on this second cause of action, okay, how did the jury find? Did they say there was a breach of contract?
They did, yes.
Yes, breach of contract, and they award her how much?
13,000.
$13,000, right? $13,000. So they were $13,000. And which court are we now and how did we get there? So the trial court found that. So the plaintiff was awarded $13,000 for breach of contract from the jury, right? Okay, what's the next procedural steps after that? How do we end up in this court we're at now?
There was an appeal.
An appeal, perfect. And which court are we in? We're in the Supreme Judicial Court of Massachusetts, right? The highest court of Massachusetts on this appeal. Okay. So when there's an appeal, someone had to appeal, right? And who appealed in this case?
It would have to be O'Connor, right?
It would have to be O'Connor. Actually, in this case, both of them had issues, right?
Okay.
Both of them submitted issues. And it amounts to issues they have with the damages, right? How we calculate the damages. Okay? What was allowed in terms of damages. And so that's what the court is looking at, right? They're looking at what we call issues. So number one, were the jury instructions in terms of awarding damages correct? That's what we're looking at, okay? And if you're in class, I would draw this from you. We would be talking about this and I would draw this from you, okay? And there's another couple of things we're looking at, okay? Now, the first thing, before we get to that question about damages, I'm gonna write about damages here in just a second, right? The appellate court talks about something as a matter of public policy first, okay? And this is on page 2 at the very bottom, right? So the court's asking the broad question about what in terms of a doctor-patient contract. Doctor-patient contract. Not everybody wants. Hard to hear, right? Doctor-patient contract. What do you think, Ms. Phillips? I can see your.
Yeah, can you phrase that question again, just so I feel like I'm understanding it correctly?
What public policy question in terms of doctor-patient contracts does the court want to answer right now?
I don't know, but I'm trying to figure it out.
It's okay. It's all right. Don't worry. No pressure here. Oh, we have right here. I think we should ask this. As a matter of public policy, should we enforce doctor-patient contracts? Should we, as a matter of public policy, enforce those types of contracts? So taking a step back, and looking at this deal, is this the type of contract that we want to enforce in a court, right? What do you think?
Yes.
Okay. What are the reasons we want to enforce a contract like this in a court? Maybe we should start with, why shouldn't we enforce this type of contract?
Well, if you enforce this type of contract, aren't you potentially setting a precedent that a doctor trying to do something and failing makes them civilly liable?
Exactly. So what is the issue with medical science and a promise from a doctor, right? I mean, think about this. Doctors it's not an exact science, right? So if the doctor says, hey, I promise to heal you, or if the doctor says, look, I feel good about this, I think we could have a good result, right? I think that might be taken by some people, some person receiving that promise, thinking that's a direct promise that can be a breach of contract, right? So what would that lead to? Would lead to doctors having more liability. Maybe. Hey, John, can you silence? Oh, thank you. I was just hearing a lot of different things there. Great. Or a doctor being careful about what they say, right? And so a lot of times we look at what doctors say and then they encourage people. They say, I have hope for you. This could happen, but they're really not promises, right? It's kind of forward thinking. It's kind of hoping. And that does good things, I think, for patients, right? But at the same time, those could be misconstrued as promises in terms of contract, right? Okay. Now, but why would we want to enforce them? I should say. What is the court word about here?
Well, I think because doctors need to be held to some type of standard.
There's got to be some type of standard, right? If we're not enforcing this, there could be a bunch of charlatans out, as they say. They worry about the charlatans. So there's got to be, a way of enforcing these types of promises from doctors, as long as they're, I think, clear and convincing. There's clear and convincing evidence that there is a promise from a doctor, right? So we're going to say, look, as a matter of public policy, courts do this often. They go back and forth between these two things. You know, if we enforce this, doctors will be performing kind of defensive medicine, right? They'll be maybe not as aggressive as they should be. I'm not saying they should experiment on people, but you want them to be, you know, I think go-getters in terms of providing the best care they can, right? So you don't want them to necessarily to be practicing kind of this defensive medicine. At the same time, you want them to be held responsible. So we're finding a good middle ground, right? So that good middle ground is, yes, we will enforce them, provided that we have clear and convincing evidence that there are in fact promises. Okay, now, so we've got that. Now, the second question we're asking, okay, is what? What is the next issue? Like, let's assume there is breach. Can we assume there's breach here?
Yes.
Is there a breach? Yes.
Yes.
Marie, there's a breach, right? We have what was promised, okay, is a heady nose, this great nose. What was delivered is a bulbous nose, right? So we have breach of contract. So the issue we have is what damages, or what should we do? How should we remedy the situation, right? Let me ask you this. How many surgeries were there?
There were 3.
3 surgeries, right?
Uh-huh.
Let me erase this.
Professor Atkinson, you have a hand raised by Sandra Perez.
Yes, please.
Hello, Professor Atkinson. I was just going to comment regarding if procedures are medically necessary or cosmetic, if they're held to different standards. So being that this was cosmetic and it wasn't a medical necessity, that that he was overpromising on something that he didn't deliver. So that was my comment.
Good, yeah. And so we're kind of mixing contract with tort. Like tort requires like a medical procedure, different types of medical procedures in tort require a certain level of performance, right? And that changes with the type of procedure. If you fall below that line, it's going to be a negligence action, right? In contract, remember, you can promise whatever you want. If you exchange that for something, right, whatever you promise can be enforced. So if you're promising a perfect nose, you better be careful. You better deliver a perfect nose. So it's all about what we agreed to. So the agreement, right? But good point. Okay, so we had 2 surgeries, right? Okay, we had 2 surgeries, then we had one more that was kind of the corrective surgery, right? Okay. Let me ask you this. In terms of contract law, would you want a court to force the doctor to fix it? Can we say, hey, look, doctor, we're going to put you in jail, or we're going to fine you every day you don't fix this? Do you want to do that in contract law? Do you think you want a court to force a doctor to do that?
No.
Why?
I would not.
Why?
Because to me, it seems like there's really no way to fix.
Number one, there's no way to fix it. That's what it says here, right?
Right.
Essentially, we can send it to another doctor, right? But this doctor has had 3 tries at this, or 2 tries and right, 3 surgeries. The doctor has not fixed it. So we don't have confidence that this doctor can fix it.
Right.
What else? What else bothers you about forcing someone to perform?
Well, as the patient, I wouldn't want that. I mean, I would say, I think 3 is plenty. You have, yeah, like you said, you've had your chance. Let me find somebody else, you know, to maybe they can fix it.
Perfect. Let me find somebody else to see if they would fix it, right? But how would the doctor feel? Do you think the doctor would be happy to be at that surgery forced by the court to perform?
Oh, no. If the doctor that had the 3 bad ones was forced, yeah, not good.
And so this is called specific performance. Sometimes we force people to do things, but when the performance relates to something like surgery, aesthetic taste, those types of things, we're not going to force somebody, you know, to perform. So that's out, right? Somebody mentions having another surgeon perform. So we have a 3rd surgeon, right? Or a 2nd surgeon, 3rd party. Okay. How would we be able to get to that? What do you think this would take? What could we get from the 1st surgeon to be able to make this happen? What would when you're talking about remedies and damages, you're talking about making the injured party, the non-breaching party, whole. So instead of forcing the surgeon to do something, what is another way we as a society evaluate injury and compensate for injury.
Yeah, that's what I was gonna
Force them
say.
to
Have-
pay, basically.
so-
Money, right? Money damages, okay? Now, the rest of this case talks about these different measurements of money damages, right? How we're going to make the injured party whole, okay? So let me write a couple of those. Let me write the 3 of them on the board that the court talks about, right? You can walk through these with me, okay? Actually, the second one they talk about is the first one I'm going to talk about, right? And this is called the restitution measurement. Okay. Restitution, in this case, is measured, okay, by what was conferred on the defendant. So we're going to return anything. So we're going to return anything, any benefits, benefit conferred on defendant, okay? Any benefit conferred on defendant, okay? Now, number 2, so think about this for a second. Any benefit conferred on defendant. Number 2, we're going to talk about expectation. Expectation damages. Okay, from your reading, what is expectation? What do you think expectation is?
I think one of the things they talked about in here was, if I'm remembering correctly, was her future jobs. Was that in
Something
there?
in the future, right?
Yeah.
Something in the future, okay. Think about where she expected to be, right? So this expectation measurement, so these are all theories of recovery. Okay, this is placing the injured party. I say injured, and injured in contract law means the party against whom breach was committed, right? Placing the injured party in the position she would have been, in this case, she had what, class?
Has she not had the surgery? No?
That is another measurement, but this is expectation. Think expectation, you're good.
And she
Take
had
that
the
Marie,
nose,
for the next one. The place she would have been had
her nose been corrected properly as
breaching
promised.
party performed the contractual duties, right? Had breaching party performs contractual duties, okay? So we got that. Now, finally, do I have room on this side? Yes. Okay, finally, number 3, Marie, this is for you, right? This is the reliance measurement, right? And this is putting injured party in what? In the position what do you think, Marie? You said this. You said it.
Oh, like it was before.
Is
Is that what I said?
Good. Status
Original
quo. Putting your back in the position as if they never crossed paths.
Okay.
Position she would have been in. Or the position she was in before contracting. She would have been in had they not contracted. Or cross paths, right? So this is like putting them back to the status quo. Putting them back to the status quo, okay? So these 3 things that we're looking at: restitution, expectation, okay, and reliance. These are the 3 things we're looking at. Now, I know the court talks about this, but I want you to talk about this with me. what are the potential things that she could seek, that someone could seek here? And what are the, what's the easiest thing you can think of? What can we give her in terms of damages? What did she pay to the doctor?
Pay her back what she paid the doctor. Give her back her money.
So how much is that? We've got, everyone have this? Can you see right here? Yes, okay. So how much is the doctor bill?
Ooh.
Like $622.
622, and that includes, right, doctor fee?
And hospital expenses.
Okay, what else? What else could we give her? So she comes in, you're like, hey, counselor, what can I get from this contract breach? So think about this. What else would we give her?
Missed work.
Okay, missed work. So I think I could separate that into past missed work and future missed work. Okay. What else?
They talked about compensation for pain and suffering.
Pain and suffering, right? Okay. So mental anguish, pain and suffering. Pain and suffering, mental anguish. So I would say as well, I would say like to date, okay? Right? Maybe future, okay? What else? Think, what else? What else would you trying to help her get everything she can? What else would you attempt to get?
Future surgeries?
Future surgeries? Okay, yeah, so another surgery, right? Another surgery from a better doctor. Right?
That is true, yes.
Okay, which would probably be more money, okay? All right, what else?
Money spent on medication.
Okay, so it's in medical bills, right? Doctor fee, other, what we'll say, medical bills, other medical bills. Okay, what about this expectation measurement? I mean, I'm giving something away, but think about this. Like, it's generally expectation is easy because you're in a commercial setting. You could say, look, hey, you promised to deliver me grade A oranges, but you delivered me grade B oranges. So what the damages are is I expected grade A oranges, you delivered grade B oranges. So the difference is what was promised, the difference between what was promised and what was delivered, right? So maybe we could say the difference between a great nose or a perfect nose, right? What you promised, your promised nose, what was delivered. So the difference between promised nose, right? And the nose you gave me, the bulbous nose you gave me, right? Okay. So the difference between these things. Okay, what else?
Professor Atkinson,
Yeah.
can you connect this to potential future jobs or the job they might have expected?
What did she say? I mean, she didn't prove this, but if you were talking with her, right, you would say, hey, potentially missed jobs. I mean, the court says she didn't prove that, but when you're meeting with her, you would say, hey, missed jobs potentially. Missed jobs, future jobs, because of his nose, right? Okay. Now, what I like to do is that we've got these rules up here for restitution, expectation, and reliance, okay? So let's walk through this. Let's walk through restitution first. And if you can see, it's return anything, any benefit, right? This is measured by what the benefit from defendant's perspective. So it's whatever plaintiff conferred on defendant, we're going to return that. Okay. So number one, the $622. Can we, if we decide to go with the restitutionary remedy, can we give that $622 back? Did she confer that to the doctor?
Yes.
Yes, she did. Okay, did she? Let's talk about it. The doctor's fee, yes, right? For sure. This 622 is broken up into the doctor's fee, which goes to him, but also the hospital bill. And I guess I know this because I work with hospitals. The doctor's bill, the hospital bill goes to the hospital, right? So if that hospital bill that she paid went to the hospital, is that something conferred on the doctor? That she conferred on the doctor? It's not. So this would not be restitution. okay? But doctor fee would be, so we've got that covered in restitution, okay? What about missed work? Did she confer missed work onto the doctor? So I'm going here, pain and suffering, is that something she conferred on the doctor? No, so when you look at this, you're just looking, you're returning restitution, you're returning anything she conferred on the doctor. And it looks like the only thing, and this is what the doctor's arguing, of course, what the restitution and remedy should be, is simply anything that he got from her. So he's saying, here you go. Then we're done, right? Okay, now, what about, let's talk about number 3, reliance. Okay, putting the injured party in the position she would have been had they not contracted, right? The status quo. How do we do that? Let's walk through these again. Is the doctor's fee, could we charge that under reliance? Yeah, on reliance of the contract, she went into debt. So yes, that could be a reliance as well. Reliance and restitution, right? So this is covered, so that reliance. What about the medical bills? To put her back in the position as if they never contracted,
Yes.
medical bills, reliance. Okay. What about the missed work in the
Yes.
past? Yes, if
Yes.
in fact she missed work, that's the reliance measurement. Okay,
Because she would have not missed work if
she
all
would have not missed work, right?
this
What
had.
about the future missed work? That might be saved for, you know, in the future, had she had the nose, right? So that's maybe not reliance. So we're trying to put them in the status quo, right? The past missed work. What about the pain and suffering to date that she suffered because of the contract breach and reliance of the contract breach? To get her back to status quo, we'd have to pay that pain and suffering, right? So that should be included, right? So this is reliance as well. Okay. What about future pain and suffering?
No, that would go towards expectation damages in the future.
Expectation, taking no expectation, good. What about the difference between the promised nose and the bulbous nose? Would that be reliance? It wouldn't, because status quo did not include the promised nose, right? Status quo just included the nose she already had, right? So this is more of that is the expectation measurement, the difference between what was promised and what was delivered. Again, reliance is simply, how do we put her back in the places that they never contracted, right? Enough money for that, okay. What about missed future jobs for reliance measurement? No, not missed future jobs, okay. Now, next thing, expectation. So we are thinking to yourself, hey, had he performed perfectly, where would she be, right? I know that we can't give her the perfect nose, but we can try to compensate her with money, right? To put her in the place that she would be, okay? And if you look at all these things, like this expectation is gonna necessarily include all of these reliance things, right? Because you have to get her to status quo, and then in addition, get her to where she expected to be. So they necessarily include that reliance measurement, right? And as you can see, future pain and suffering. If you can show, hey, look, had I had this perfect nose, I would have been in Casablanca. I don't know, right? So if you can prove that, then you can get that. You know, you can prove another surgery. I mean, I was gonna get to another surgery, like potentially another surgery could be reliance, right? To get her at least back to status quo. But for sure, it's expectation, okay? The promised nose, the difference between the promised nose, the bulbous nose, right? Missed jobs. So all of this is placing the injured party in the position she would have been had the breaching party performed the contractual duties. Okay, so these are the three measurements we're going at, right? Now, if you were judging this, and I know that the court picks one, and what does the court pick? What does the court pick?
Expectancy?
They don't. So why, Marie? Why don't they, what is the problem with expectation damages or expectancy damages? What do they specifically say about expectancy in this right here? What's hard about this to figure out? I mean, what do you think is hard about this? How are we going to assess and how are we going to put a number on this, right? It seems like the damager is too speculative, right? To be able to really put a number on the difference between the promised nose and the bulbous nose, right? It seems like we can't put a number on there. We'd strain our imagination to figure out, really, if she had a perfect nose, what jobs would she have gotten? We don't know that. It's very speculative. So the court was not comfortable. Kaplan is the judge. He was actually professor of contracts at Harvard before he took the bench. So he knows what he's talking about. And not all judges do. Just get ready to analyze these cases, and you're going to make your own decisions about if the judges know what they're doing or not. And that's a good thing. That's what we're training you to do. To have, we're not training you to follow everything you see. We're training you to say, hey, the rule is this. And I agree that the court applied it correctly or not. Hey, or the rule should be something else, right? So that's what we're training you to do. But it's difficult for a fact finder to put a number. It's too speculative, right? So the court says, look, and then restitution is too small, right? So at least we can give reliance, and that's the best that we can do, give the reliance measurement. And that's the best we can do. And in fact, he doesn't have to choose, right? Because she basically says, hey, look, I'm okay with just the reliance damages anyway, right? So she doesn't even go for expectation damages. Okay, now, what would you have given her? Or what are ways we could calculate? Let me ask you this. What are ways that we could calculate the difference between what was promised and what was delivered in terms of money? How would we prove that? What do you think? This is the issue we have with expectation. It's, think of any expert you could have testify about what it's worth. And how would we prove these things?
Could it be dependent on the amount of money she may have made if she had been in the film?
And how do you show, number one, if she would have gotten the film? How do you show which film? Do you see what I'm getting at, Marie?
Right.
This is why it's difficult. This is why the reliance measurement, at least in terms of patient-doctor contracts, is probably the best measurement that we have, right? Okay, now, there you go. That is, so we would have, probably 3 cases we go through as per class. And then after that, we would run through the rules that we went over, right? We would talk about, and we would run through what restitution is again, and we get that rule down. We'd run through expectation, get that rule down, and we'd run through reliance, get that rule down. So we would talk about the rules you should have pulled from the case. And what I would do right after that is I would give you another fact pattern that's similar but different, right? And so what I would make you do is I'd make you apply these rules that you learned in a new fact pattern. They're called hypotheticals. And so that's what we do over and over. Pull rules, give you new hypotheticals, make you walk through those rules. Make sure that you're learning those rules and how to apply them in law school. And again, this is a much better experience when you're all here. And it's a lot of fun, I think. I think it's much different than from what students are used to, kind of professor standing up here, with a PowerPoint, you walk through the PowerPoints. That's not what you're going to find here. There's a discussion happening. So that's my mock class. And I think that if you have any questions about this or want to connect with me, please send me an email. And Dan, could you forward them my email address? It's on the website. I'm happy to answer any questions. But welcome. I'm glad you participated today.
Yeah, Professor Atkinson, that was very exciting. It's amazing how well it delivers even. I felt your passion for the subject. So tell us, how did you end up teaching contracts? Is that something that you are really
I love language. I have a degree in Latin American literature. I love literature. I love language. I've always loved language. And so language, equals in law, I guess, reading statutes and things, but I think contract law really fit the best for me. And I always tell my class this, I say things like, the arbitrary nature of language is what's fun. I mean, I can say things like, hey, in our class, we're gonna call that clock table, right? And so like for our class now, I'm gonna say, if you, that clock is called table, right? So whenever you think of table, you're thinking of that clock. So the word is not the thing. The word is arbitrary, right? It just makes you point to something. So contract law is a lot like that. You can have people talking about contracting for something, and they both have that signifier, something very different in their heads. It points to different things and maybe don't match up. And so I like to explore those types of things. And as a practical matter, there's not a lot of really experts in specifically contract law. So that's one thing that I wanted to get into. I wanted to really be an expert in contract law. And it just fit with my passion. So, and I think that a lot of students come into law school thinking that contracts is going to be the most boring class, right? Think of contracts, but it's not. And this is why. You're contracting almost on a daily basis. Whenever you click on an agreement, if you're buying bananas at a store, that's an implied agreement. If you're getting a haircut, you are always contracting, right? So think about all the times you're making an agreement, either expressly or impliedly during the day. And so I feel like when students come to campus and learn about contracts, they already know a lot about it because they've been doing this their whole lives. So I really love it.
Yeah, thank you. And what about Professor Atkinson, when you think back when you were in these students' shoes, thinking about going to law school, what inspired you to go on and become a lawyer?
I think that that law school and a law degree and a license allows you to do certain things that a non-licensed person can do. You have direct access to effectuate change in whatever you choose to do. If you want to work in immigration law, if you want to work in low-income populations, you can effectuate change immediately because you have a key to the courthouse, right? And so it's like immediately you can just knock down the door and file an action and effectuate change immediately. So I liked that. I like the ability to not just discuss things and think about things and think, yeah, that's terrible that they did that, or that should be changed. I wanted the ability to actually effectuate change. So I think that's one thing you should be thinking about, is that it's a very powerful tool that can be used for a lot of good. If you want to come and get a law license and make money with big corporations, great, good for you. But you can also use it to do a lot of other things that are very, very important.
Great, fantastic. Yes, I really do believe it opens up so many doors for people that they could even hang their own shingle and become unemployed. And there's not a lot of careers that you can go into and invest that time and resources that open up that much for your life. So thank you. That was fantastic. Thank you so much, Professor Atkinson.
You're very welcome.
We appreciate you. And you do teach the daytime contracts class. Who teaches the evening class?
Larry Artinian has been doing it for almost 30 years. So he's very good too.
Awesome. Great. Well, I will, unless any people on the call have a specific question to Professor Atkinson, go ahead and ask that now. Otherwise, he will sign off, and my colleague, Francisco Rosas, and I will remain on the call to answer any additional questions for you.
All right. Oh, go ahead.
Yeah, Professor Atkinson, looking at the case, I see that there's some numbers that have an asterisk beside them and they're bold. Could you explain to me what that is about? Thank you.
Yeah, so originally these cases were in books, and that references the actual page number of the physical book.
Great. Thank you, Marie. Good question. Anybody else? Any final questions for Professor Atkinson?
I have one really quick, Mr. Atkinson, if you don't mind. Is this, when they decide a contract case, they basically just pick from one of these options, like the either restitution, reliance, or expectation, and then that becomes the guideline for how they award damages?
Yeah, assuming that you'll learn this, assuming that they publish the case, it's a published case, then it'll have precedential effect on the lower courts. So in this case, contract law is largely a matter of state law. And so this is the highest court in that state. So they could technically make a new measurement if they wanted to.
Got, okay,
Common law. Yeah,
thank you.
you're welcome.
All right, Professor Atkinson, if you want to go ahead and give any final words of encouragement to this group that joined your class, please do that, and then we'll sign off with you, and Francisco and I will take over.
I hope to see you soon. There's never a better time right now than to be a lawyer. So, and it's not always been the case. That's not always been the case, but it's a great time to get a law degree. So hope to see you soon.
Great, thank you so much.